Imagine you're running a business out of your garage. You want to form a corporation, but your business assets have appreciated and you don't want to pay tax on the gains when you transfer them to the corporation. Good news, Section 351 of the Internal Revenue Code allows you to transfer property to a corporation without recognizing taxable gain or loss. However, you must control the corporation immediately after the transfer. The United States Tax Court chiseled down this control requirement in Intermountain Lumber versus Commissioner. Dee Shook owned a sawmill. After the mill was damaged, Shook partnered with Milo Wilson to rebuild a larger sawmill. The men formed S and W Sawmill to jointly own and operate the mill. Shook executed a bill of sale and deed transferring the sawmill's assets to S and W in exchange for nearly all S and W's shares. The same day, Wilson and Shook entered an agreement whereby Wilson was entitled to purchase half of S and W's shares. Shook deposited half of S and W's stock certificates with an escrow agent. Shook also executed an irrevocable proxy granting Wilson voting rights in half of the shares. A few years later, Intermountain Lumber purchased S and W. On its tax return, Intermountain claimed an adjusted tax basis in S and W's assets based on their fair market value at the time of incorporation, rather than Shook's original lower basis. Upon review, the Commissioner of Internal Revenue determined that Shook's transfer to S and W was non-taxable under Section 351. Thus, Intermountain was required to take a carryover basis in S and W's assets rather than a higher basis according to fair market value. Intermountain filed suit, challenging this determination. Intermountain asserted that Section 351 didn't apply because Shook didn't have the requisite control of S and W immediately after the transfer. The tax court considered the case.